Currow, CEO of ANROS, and I'm delighted to be able to accept the invitation from Elena Campbell, who is the lead researcher on the ANROS-funded PIPA project, to facilitate today's webinar. I begin by acknowledging that we're on Aboriginal land where we meet across the country today, and we pay respects to Aboriginal and Torres Strait Islander elders past and present, and also acknowledge emerging leaders. So we're on a fairly tight timeline today. We've got 1 hour for this webinar, so we'll be sticking to time. I just wanted to give you an indication of the format for this afternoon. So we're going to begin with.
Sorry, I don't know.
Sorry, could I just ask people to turn their microphones on to mute, please? We're getting. Okay, so if all microphones could be turned to mute now, that would be very much appreciated. Thank you. So after some initial introductions to the panellists that we have for the webinar this afternoon, we'll move to an overview of the PIPA project findings, then a conversation with the panellists that I'll facilitate. Then I'll hand over to Elena Campbell to take audience questions via the chat function. So you should be able to enter questions via the chat facility, and that we can then get through as many as we can by the end of towards the end of the webinar. As I've said, please remember to keep your microphone muted and your camera off, so that we can ensure that there's no interruptions to the speakers as we go. As I said, we'll have to finish promptly at 2 p.m, so we must keep to time. So now it's my pleasure to introduce the panellists to you. First of all, I'd like to introduce Elena Campbell, Associate Director, Centre for Innovative Justice at RMIT. Elena has worked in legal and social policy for 20 years as Associate Director of the Centre for Innovative Justice. Elena oversees a program of research which focuses predominantly on family violence and relevant court processes, as well as the connection of gendered violence with a rise in women's incarceration. Dr. Helen Cockburn is from the University of Tasmania. Dr. Cockburn is the coordinator of police studies within the Faculty of Law and lectures in criminal law. She served as a researcher in the Tasmanian Law Reform Institute, and law reform continues to influence her research, including a commitment to promoting professionalism in the police force in Tasmania. Brittany Clark from Legal Aid Tasmania is a criminal lawyer at Legal Aid Tasmania, where she has worked for nearly 4 years after leaving private practice. Brittany runs the youth-focused practice at Legal Aid Tasmania, and this includes regular appearances at the Magistrates Court, including the Youth Justice Division. Toby Stoddart is the program coordinator at Colony 47, one of the largest providers of integrated youth services, as well as the lead agency for Housing Connect in southern Tasmania. Toby coordinates the recently established Step Up program working with parents and young people using violence in the home. We're going to go to our panel discussion in a little while, but to give us context for the panel discussion, Elena Campbell, lead author of the PIPA project, is going to take us through some of its findings, giving us a foundation for our discussion in terms of how these might inform efforts in Tasmania in coming years. So it's now my great pleasure to hand over to Elena Campbell for a presentation. Thanks, Elena.
Thank you very much, Heather, and thanks so much for agreeing to join us today as our facilitator. It's fantastic to have the support of ANROS for the PIPA project and the support of ANROS throughout what has been a bit of a journey and a labour of love for me and for the PIPA team. Behind the scenes today, we've got Heidi Phillips, who's going to be fielding any kind of questions that you want to put in the chat about technical issues. And Heidi, if you could just move the slides on now, I'm going to report on the PIPA project findings. Just to the next one, thanks. Okay. So the PIPA project is a project that started in we started work in 2017, and it was a multi-jurisdictional study involving focus groups with over 150 practitioners from a wide range of service types, overseen by a steering committee of really senior stakeholders, including the President of the Children's Court in Victoria, the Commissioner for Children and Young People, And if people could just mute their mics when they're coming in, please. Thank you. And just as importantly, it involves reviews of over 385 legal and court case files from across 3 jurisdictions. And the purpose of this is because we wanted to understand not just a sort of issue of prevalence or demographics in relation to the use of family violence by adolescents. We wanted to understand the narratives in these kids' lives.
Yummy rolls.
Heidi, are you able to mute other the audience members, please, if that's possible? Thanks. And obviously informed by a detailed literature review. If we could move to the next slide, thanks. Okay, I think we might have lost that. The purpose of Heidi, are you able to move to the next slide, or should I do the slide sharing? Oh, thanks. We've skipped ahead, but that's okay. Let's just stay on that one. The purpose of looking at having that back the other way. That's all right. We'll just leave it there. The purpose of looking at 3 different jurisdictions was because we wanted to. We would have ideally loved to do a national study, but we wanted to look at 3 jurisdictions that had quite different responses or frames to respond to family violence overall, or were at different stages in those frames. So, for example, in Victoria, there's been an expanded definition which has captured AVIS, or adolescent violence in the home, since 2008. So police and court statistics have gathered as a result tell us a certain story about AVIS, and that police and court data over the last 10 years tell a fairly consistent story about its prevalence, being that around 10% of police family violence call-outs involve adolescents as respondents, and a slightly lower but nevertheless consistent rate of intervention order applications are brought against adolescent respondents. So it's been a consistent story in Victoria for quite some time that adolescent family violence is a significant proportion of the family violence to which our system currently responds. And we might get on to later the fact that it will be interesting to see what the impacts of COVID during an extended lockdown in Victoria due to that data. WA has had an expanded definition of family violence since 2017, and a definition which is quite similar or arguably a bit broader than the one in Victoria. But when we conducted our research, the legislation hadn't been in operation for a sufficient period of time for that to be showing up yet. So we looked at youth crime files instead, and I'll explain that in a minute. Tasmania, of course, which is the focus of today's discussion, is different again. It recognises intimate partner violence perpetrated by individuals 16 and above. So officially, AVIS does not exist on the legislative books in that same way as it does in Victoria. So we wanted to look at how those different settings in 3 different places can influence the extent to which a phenomenon is seen or recognised and therefore met with any kind of response. Heidi, if you could move forward now on the slides. What we found in Victoria, as I've said, in relation to there's been consistent data, which could be assumed to tell quite a singular story. But what we found was that our file reviews in Victoria really problematise that story and that idea of the prevalence, because we did not find a singular AVIS narrative in the stories of kids and families coming into contact with the courts in the context of adolescent family violence. Some cases didn't appear to meet the legislative definition, and yet an application was brought nonetheless, and that was a reflection of the limits of police discretion in Victoria. Some met the pattern we expected to find, and that literature, existing evidence indicates are strong themes in that behaviour being controlling behaviour, a range of co-occurring issues, mental health, AOD use and school disengagement. If you can move to the next slide, Heidi. What we also found was a significant rate of disability within the case files in Victoria. So about 50% involved children diagnosed with some sort of disability, and most significantly 25% featured an adolescent diagnosed on the autism spectrum. Now, the relevance of this is that there's no requirements in the relevant legislation that a court consider someone's capacity to understand or comply with an order that's imposed on them. And that contrasts with other more generic civil restraint order equivalent legislation, as well as with the criminal law presumption that children under 14 do not necessarily understand the nature of their behaviour. Well, when we combine that with the significant number of kids under 14 being made subject to protection orders regardless of disability, this told us that the Victorian system was putting vulnerable kids at risk of criminalisation. Perhaps even more concerningly, the files also revealed that violence was often occurring in multiple directions across family structures, a bit like sort of this, but the child was the system's sole target. And in some very concerning cases, a small number of files revealed parents using the system to perpetuate emotional abuse against their child. So the system was inadvertently colluding where the child perhaps was resisting against that abuse that they'd been experiencing for years. And in that sort of incident-focused response that we know is such a problem across family violence more broadly, that meant that they were the target and bearing the burden of the system's response. If we could move down now to the next slide, thanks, Heidi. In Western Australia, as I mentioned, when we did a file sample, the definition hadn't necessarily been in operation for long enough for us to look at family violence specific orders. So what we did is we contrasted it with a sample of criminal files to see whether that was sort of something that was, AVITH was something that was visible to the system by virtue of the matters that were being brought in criminal courts. And we found that 11% had an explicit AVITH-related charge and a further 11% featured AVITH in the narrative. But in the majority, the experience of violence was documented, but not the use. So, for example, you might have a child charged with aggravated burglary. It was in the context of a break-in where they were living homeless or couch surfing, and that was in the context of having been kicked out of home for using or violence, often in situations where they'd experienced it for long periods themselves. On our return in 2018, we heard that there had not been a noticeable pattern of orders brought under the expanded legislation, but we were told, and this is a significant thing, significant for how different levers in policy settings work together and combine to produce certain results. So unlike in Victoria, where police are prohibited from advising victim survivors to seek an application on their own, in WA, police don't operate with similar imperatives. So that in turn may mean that rates of specific family violence orders against adolescents in WA don't echo the same sort of prevalence in Victoria, despite that similar definition. But many more recent reports suggest that this is changing, and we'll be exploring that with a WA panel next month. Heidi, if you could move to the next slide. Now, of course, in Tasmania, which is the focus, I've explained the Victorian and WA settings just to give you a bit of a contrast. So we can consider what it means when we have different legislative and policy settings, which then drive a certain service response. So when we went to Tassie, we initially heard that we wouldn't be likely to find this issue on court files because of that legislative decision to limit the definition of family violence. And we also heard that this decision was very deliberate because there were concerns that other forms of family violence required a more therapeutic response. But what we eventually found was that amongst generic civil restraint orders, so for those of you outside Tasmania who are listening in, legislation which you might use to bring an order in a neighbourhood dispute, or I know in Queensland, Heather mentioned that there was something called the Peace and Public Order legislation or something similar. So very generic orders were being brought against child respondents. And in the sample that we looked, of all those brought against child respondents in a certain year, 36% related to young people's use of violence against family. And the young people on those files were often in crisis accommodation, and physical violence tended to be very severe. It's because members' family had sought the legal system's help as an absolute last resort, which we know, of course, is a theme across AVITH in general, but appeared to be even more acute in the context of there being very few services available for families to address that behaviour before it got to a very, very alarming severity. And unlike in Victoria, where the majority of protection orders applications are sought by police, nearly all of the applications against adolescent respondents in our sample were brought by police. Tasmanian families were being told by police to seek the application themselves. So Heidi, if you could move to the next slide, please. And of course, being told to seek the application yourselves is obviously functions as a significant barrier, because what we saw on the files was that mums who are generally bear the brunt of this kind of violence from their kids were very fearful of the consequences they'd experience if they sought a restraint order. And they were very worried just as much for their child, because they didn't want to propel them into criminalisation. The theme of prior and current victimisation in those kids and those files, and more broadly, was almost universal across all of the files that we saw, and with all of the practitioners to whom we spoke. And that included unaddressed trauma in the lives of mums, functioning as a barrier to effective responses, and family law issues playing out for years, including violent fathers coaching kids on the sidelines. So a common observation that we heard right across the research was that if we're intervening in AVITH, we're intervening 10 years too late, because families needed a lot more help and service response when children were much younger. Heidi, if you could move to the next slide. I think we've skipped one, but that's okay. What we also heard, no, that's okay if you could go back to the panel discussion, thanks, and we might just stop the screen sharing there, that's fine. What we also heard particularly was about the lack of service support for families in these situations. So in that sort of escalation that I've referred to, where essentially there were very few service supports available for most families, and it wasn't until it reached absolutely crisis point that then they were felt compelled to call the police, and then police would often encourage them to bring a restraint order application themselves. So the services that were available in many cases were a school counsellor, until kids tipped over into a criminal justice response. And then, ironically, this is something that Tasmania and Victoria had very much in common, that's where the therapeutic response came into play, where and Tassie has a very kind of therapeutic youth justice focus. And we heard time and time again, kids will get help when it tips over to that point, and that's where we know something useful will happen. But up until then, our hands are tied. And unfortunately, that's something we heard in Victoria as well, because of all of the levers driving kids, or driving the rate of civil family violence intervention order applications in Victoria, with none of the checks and balances, none of the risk assessment, none of the sort of sense of, does this kid even know or understand the nature of their behaviour? That's not present in the civil environment in Victoria either. So it's not until a kid tips over into the criminal justice system that they can access diversion and any kind of therapeutic response that might address the kinds of behaviours that they so desperately need help with. And Heather, I think I've kept exactly to time.
Oh, you've done extremely well. And thank you very much for that overview of the research findings, and particularly setting the context with the comparison with Victoria and Western Australia to set the context for the discussion in Tasmania. So with the PIPA findings as a foundation, we'll now turn to questions for each panel member, drawing out their particular expertise, although I expect the conversation will be fairly organic. And after that, we'll have 10 minutes for audience questions that can be submitted through the chat function. And we'll try to get to answer as many of those as we can. Although you might appreciate that some of the questions you submit might actually be answered throughout the panel discussion. So we'll move on then to the questions for the panel. I'll start with you, Helen, Dr. Helen Cockburn. Helen, when we came to Tasmania in 2018, and I was pleased to be able to be on that journey with Elena and Rob Hulls in the consultation that was conducted there in 2018. But a key question at that time was whether Tasmania's policy settings, including the legislative definition of family violence, should be broadened to recognise the use of violence by adolescents against other family members. Obviously, it's a question with no simple answer. But what was your view then, and has it changed as a result of this research? You're on mute, Helen. Well done, but could you turn it off? Thanks.
Thanks, Heather, for reminding me. I knew that would happen. Originally, I was of the view that actually the safe at home focus on a single category of familial relationship was actually quite appropriate, and that the definition of family violence shouldn't be broadened to include adolescent violence in the home. So AVIF here. I don't know that my view has actually changed in that regard, but you know, I can certainly say that I've become less certain of that position through my involvement in the PIPA project and becoming more educated about the issues of adolescent violence in the home. Seeing those figures about the number of children who are the subjects of restraint order applications. And perhaps personally for me, what I was particularly affected by were in the focus groups disclosures about the really desperate plight of families who are struggling to try to deal with violent behaviour from children who also have disability. That for me really was a really poignant part of this whole process. So on the one hand, you know, there are arguments for retaining a very narrow focus, and I think the tailored response allows Safe at Home to provide a really strong and appropriate response for that particular cohort of victims. And, you know, the Safe at Home focus is really based in a justice response. So it's pro-intervention, pro-prosecution, presumptions against bail. So trying to expand that, given its sort of policy setting, is going to be problematic, and it's not a one-size-fits-all model by any means.
Okay.
And I think generally the appropriateness of prosecuting children in this context is, you know, there are really serious issues there that we need to consider. On the other hand, you know, if you recognise this cohort of offending as another example of family violence, it will get the attention that family violence obviously has got. So intimate partner violence, the level of, you know, recognition. So at the moment, this type of violence doesn't, you know, it's not getting that recognition, and as a result of that, it's not, victims and families are not able to have access to the sorts of support that they might otherwise have if it was a question of intimate partner violence. And I think really importantly, this AVIF is not being captured in the data, and that's such a vital thing in terms of recognition of the violence. You know, empirical research is so important. You have to build a basis. If you're going to be arguing for increased resources and support services, you need that research, that empirical basis to really make that point really strongly.
Yeah, thanks, Helen. And I think you also made the point well about the importance of lived experience as an evidence base for informing policy in this and indeed any area.
Yeah, absolutely.
So I think you've probably touched on some of the other questions I wanted to raise with you to some extent, although perhaps a little bit obliquely. But so I will put those questions to you. But if you could keep the answers fairly short, that would, I think, will help us with the time management. But first of all, do you think that current legislation providing for civil restraint orders could be amended to respond more effectively to this cohort? You know, you talked about safe at home, and you know, just thinking about the civil restraint orders specifically.
Yeah, I think perhaps the biggest failing of the civil restraint orders is the limited options that are available to, you know, magistrate in imposing orders. So the family violence orders, there's much greater discretion for a magistrate to sort of tailor an order to fit the specific individual and the specific circumstances. So if you want a really short answer, I think while I think there is a real question about whether it is possible to amend the civil order framework to make it fit, I think the really important focus there is looking at the discretions that are available to the judicial officer, and also the focus on the effectiveness. So what comes next? If you impose an order, you know, that the young person is prevented from going home, what comes next? What do you do with the young person, particularly in an environment where there's a lack of crisis accommodation and all those sorts of issues that I don't think the generic orders are capable of addressing.
Yeah, so I think, and again, you've touched on this point that I wanted to ask you about, and thinking about alternatives to legislative recognition. So you've talked about, you know, safe emergency accommodation for young people as an example, but are there other things that you'd, you know, add to that in terms of alternatives to legislative recognition of this issue?
Yeah, I think, look, fundamentally, we need to be looking at therapeutic interventions, and we need to be looking at interventions much earlier on. It's, you know, it's almost too late at the pointy end where, as a last resort, families have brought in the police to try and deal with the immediate situation.
Yeah, thanks very much for that, Helen. I want to turn now to Brittany. Brittany, can you tell us about the levers at your disposal within legal aid when a matter like this comes to court? How does Legal Aid Tasmania encounter these young people and or their families?
Oh, well, Heather, at Legal Aid in Tasmania, we're in a fortunate position where we offer representation to any young person that's appearing in the Youth Justice Division. So that includes civil restraint orders, and it includes people appearing in relation to criminal matters. The difficulty as a legal practitioner working with young people who are exposed to the system because of this particular reason is becoming involved with them at an early stage. Often it probably doesn't take anybody by surprise that the young people that we're talking about today don't usually have the organisational skills or the support in their life to instruct a lawyer on their own. So how I would usually become involved with them is by meeting them for the first time, either at court or sadly in the remand centre cells when they've been arrested and detained by police in relation to one of these restraint order applications. So I don't usually get the opportunity to give these young people any advice before they're served with a restraint order application or before they're arrested for that purpose. I usually become involved once that's occurred. Now, I might just take a moment to point out that in Tasmania there is a power of arrest with youths for the purpose of making a restraint order. So sadly, we still have a situation where we have young people who are being arrested by police for the purpose of making a restraint order and often detained to appear in court so that that order can be made. So that sees them spend a night in custody, for example, and exposes them to the traumas that come with that process. So I would usually become involved once I'm aware that there is a young person in the remand centre cells that's been served with a restraint order, or if it's one of these civil restraint orders, then I would meet them at court. I'd see them in the list and I'd approach them at court to see if they require my assistance. There are still young people who fall through the gaps, however, because in Tasmania, and I'm sure it's the same in other jurisdictions, restraint orders can be made ex parte. So a young person who's the respondent to a restraint order can have a restraint order made against them without them actually appearing in court. The other difficulty is that our Youth Justice Division of the Magistrates Court only sits 2 days a week. So if an urgent restraint order is made or a civil restraint order is sought on those other 3 days, usually they would be directed to the adult intake court. And as a result, I'm not necessarily there to become aware of this particular young person and to offer them assistance. As Ellen has outlined, though, that once there's a restraint order in place, more often than not, there'll then be criminal charges that relate to breaching that restraint order or other related charges. So once that occurs, that gives me another opportunity to become engaged with those young people. I think, Heather, I've probably answered the second part of your question first. So I'm just going to come back to the first part of your question, and that was what levers are at our disposal when a matter like this comes to court. As Elena has outlined, one of the difficulties is that there isn't a lot of support available until the young person actually becomes part of the criminal justice system. So once they're actually in the system and they're appearing in the Youth Justice Division, that's when we really have the opportunity to link them in with the different supports that are available. We have a very therapeutic and collaborative approach in Tasmania to youth justice. So each time the Youth Justice Division sits, there is the same youth justice lawyer, so that's me. There's also the same representative from the Education Department, somebody from Save the Children, someone from Youth Justice, and there are other support services represented at the Youth Justice Division. And that then gives us the opportunity to work out where this particular young person requires support and then link them in with the various services. So what that might look like is arranging a bed for them at a youth shelter if that's relevant. It might be arranging a re-engagement meeting with school, referring them to programs like the Save the Children's bail program. So that's a program which engages young people with extracurricular type activities whilst they're on bail, or making referrals, for example, to the programs that I'm sure Toby will talk to you about in a moment, like the Step Up program.
Mm-hmm. Okay, thanks for that. And I think I did want to ask you about the needs of the young people and their families, and the kinds of support that they've received. You've touched on that a bit, but is there anything that you'd like to add in terms of specific needs of your clients and their families and how they are addressed or not?
I think the needs in terms of what my clients are experiencing change as the matter progresses through court. So before there's a restraint order made, for example, or before there are charges, then they're facing one set of difficulties, but that they increase, if you like, as the matter progresses through court, because once there's a restraint order made, then almost inevitably there will be an order, for example, which means that they can't be at their family home. So then homelessness becomes an issue. Once homelessness becomes an issue, if truancy hasn't previously been an issue, then that becomes an issue. Supports in terms of health and mental health become, well, they increase once the young person's away from the person who's previously been their primary caregiver and is now in some other sort of accommodation facility. So it's a matter of responding to the needs as they arise, if you like.
Thank you. And just finally, tell us about the current civil response, how it compares with the criminal response in terms of youth justice practice in Tasmania. Again, you've touched on this to some extent in terms of talking about the very therapeutic approach, but, you know, specifically what kind of intervention would make a difference for these young clients and their families at that point of contact with the justice system?
Well, the short answer to that, Heather, is that there isn't really a difference in how the court responds to civil restraint orders and criminal matters. Either way, they're exposed to the youth justice system. We at Legal Aid, whether you're responding to a civil restraint order or whether you're defending criminal charges or are responding to a restraint order that's brought by Tasmanian Police, you're entitled to representation. So we'll assist the young person regardless of how they've entered the system. In terms of what kind of interventions will make a difference once they've reached the justice system, that's a question that I could spend the next 20 minutes on, but to keep it short, there needs to be better interventions in terms of mental health at the moment. The supports that the referrals the court can make in terms of mental health are very limited. We have, the court can make an order under Section 105 of our legislation, which essentially adjourns proceedings whilst an investigation is held into a young person's mental health. But the powers that then follow that are very limited. There's not a lot that can happen after that investigation has concluded, in my experience. As part of bail support programs or sentences, referrals can be made to the Child Adolescent Mental Health Service, for example. But again, that depends on whether or not CAMS has capacity to assist that young person. And outside of that, there are very few referrals that can be made. We have one from memory service that assists young people with alcohol and drug counselling, so a referral can be made to that, but really we just need more programs that can be utilised in terms of bail support, but also interventions as part of a sentence.
Okay, all right. Thanks very much for that, Brittany. I need to move on to stick to the timeline we have. So I want to now turn to you, Toby, and I'd invite you first to tell us more about the work of Colony 47, which is supported by Communities Tasmania. Tell us about the program, what it's based on and how it works.
Thanks, Heather. So we're talking about the Step Up program, which I'll just start by saying that it was a pilot program that ran for 22 months, and we currently don't have funding for it past June 30 this year, so we're hopeful that that will continue. The Step Up program is based on an evidence-based program from Kings County in the US, which is a statutory 21-week group work program. We've obviously adapted that to our context, and we looked at a 9-week program that it's a skills-based restorative practice program. It focuses on interventions like understanding violence and abuse, understanding the impacts of violence, and a lot of safety planning and building responsibility for young people for their choices. It's because of our context here in Tassie, the idea was that hopefully we would have some level of statutory referral and some level of voluntary referral. And the program was to offer service to in the context of intimate partner violence as well as adolescent violence in the home. And what we found was that it was firstly trying to get a group work program that was voluntary in this space was really difficult in our small communities in Tasmania. And we also found that a lot of young people voluntarily ready to address their violent behaviour at home as it was really meeting their needs. So we found that the space where Step Up really had a significant impact was in supporting parents and empowering parents to start to shift their responses to the behaviours in their home. And this in turn allowed young people to start to make different choices and to say, hey, actually, I am going to need to shift my behaviour. And it was then that they started to engage in our program and would look at those strategies around emotional regulation, safety planning, understanding their responsibility in their behaviours. So that's sort of where our program landed, was that it really became a program that empowered parents to assist their young people to choose to change their behaviours.
Yeah, great. Thanks very much for that, Toby. It does sound such important work, and I do wish you well with securing continuing funding for that, for Step Up. Can you tell us a little bit more about the needs of the families and young people who come to the program, such as, you know, what are their particular needs, or are there needs of individuals or specific communities that you could talk to us about in terms of the program?
Sure.
Who's coming to the program?
Yeah, so look, there certainly was a lot of young people that were living with disability were referred to our program. And as Brittany touched on, I think we really saw the lack of mental health support for young people in Tasmania. And I think it's been spoken about as well today that we were working with a cohort of young people there was a history of family violence quite often in their family. And it's generally the mothers that we were working with, and generally mothers that have experienced family violence and their children have witnessed family violence. So I guess that's sort of a generalisation of the types of people that we were working with, and their needs really were mental health, disability support, alcohol and other drug support, and specific support around family violence, which the issues often were perhaps not right there ongoing, but certainly still having an impact.
Yeah, okay. So just quickly, if you can, are there wider supports beyond your program that would make a difference? So, for example, you know, how much can your program do on its own, or how much more support is needed beyond your program?
Yeah, look, I think it's that early intervention space, trying to address these needs earlier on in family conflict. So I guess, you know, mental health services, family violence services, really getting in there earlier. And what services can support our program? Mental health and alcohol and other drug services are really
Okay. Yeah, it's a very common theme. So, yeah. Thanks. Yeah, thanks very much for that, Toby. I think we've probably got, I have a number of questions I'd love to put myself to the panel, but I'm conscious that there are audience members. I've seen questions coming through, and I know that you've got questions as well. So I'm just going to put a question to Elena. I'm particularly interested to know what the PIPA project finds was effective in working with young people and their families experiencing violence.
So thanks, Heather. And there are a lot of great questions coming through, and I'll try and address in a way some of those within that. The challenge that we've had in relation to adolescent family violence is partly that it's been, a form of family violence that's only recently been recognised. So specific responses have not had the policy focus and investment that is necessary to meet such a significant policy area. And but what we found is that our system is geared very much towards a one size fits all response, both in legally and otherwise, and that responses that expect kids to be able to come to the same sort of program at the same time each week, very much compliance-based and very much focusing on one issue when they're faced with a whole range of needs, as Toby has identified and as Brittany has identified as well, that essentially what is needed is a collaborative approach. So some of the questions coming through are that the most recent being, for example, could there be programs for youth that are similar to men's behaviour change programs? Well, Step Up is actually, and there's another question about restorative justice and responses, and Step Up is actually, and Toby, you can jump in and kind of correct me if I'm wrong, but as envisaged in its initial manifestation in King County in the US, is that it's essentially a combination or taking lessons from responses to adult family violence and lessons from reparative or restorative approaches and putting them together because of the fact that kids and parents don't essentially want their relationship to end. They want it to be repaired, but they need help. Often they need help. Yeah, that's fair. That's a fair characterisation, Toby. Thanks. So often they need help because they haven't learnt how to parents haven't necessarily seen, positive parenting themselves. Mums might be significantly affected by the trauma that they have experienced, because one of the other questions coming through is essentially that women's experiences of trauma from intimate partners are not necessarily recognised, or they're not supported in their recovery sufficiently to then that starts affecting how their relationships with their children work. And of course we know that children who have been exposed to that then are far more likely to replicate or replay that violence when they hit adolescence. So one of the things that we found is that essentially what this is today, and this is one of the purposes of this webinar today, and the project that across the project that we had focused on, is bringing people together where different agencies, no one agency can respond to all of the issues that families face, and instead agencies working together in a collaborative response where everybody knows who to call at a certain point and who is best placed to deal with and support the issues, so that the whole family is held properly by the support service system.
Yeah, thanks very much for that, Elena, and thank you for picking up on some of the questions that are coming in from the audience. Are other panel members want to jump in at this point to, talk about what other opportunities there are for these kinds of responses to be developed or strengthened in Tasmania, and any barriers or challenges you see, before I'm going to hand over to Elena to actually facilitate the audience questions. But I just wanted to give an opportunity to other panellists to respond to those points that, or to add to those points that Elena has raised there. No pressure, it's just an opportunity, but really I'm particularly interested in the opportunities for the broader kind of responses to be developed or strengthened in Tasmania in particular.
Yeah, Heather, can I just jump in there?
Sure, Toby. Yeah.
I think that's what the Step Up pilot was really aimed to try and do, was to find a model that might work in our context, and to find a model that might work in a space where there's not a lot of statutory response. And what we found, as Elena has said there, that really it had to be a response across the service sector, and it needed to be collaborative. And a lot of what our program did was, yes, it was restorative relationship work based on respectful relationships, but a lot of case management. And that's, I think, quite often a missing link, is that case management to pull services together.
Yeah, great. Thanks, Toby. So I'm going to hand over now to Elena to facilitate a response from relevant panel members on questions coming through from the audience. So over to you, Elena.
Okay, well, a lot of the questions essentially centre around what do people see, or what is the evidence around the presence of trauma and victimisation in children's lives. And so I suppose certainly the evidence indicates that kids who use family violence against their family members are more likely to have experienced that violence. And we know that in terms of that sort of sense of, as I mentioned before, social learning and replaying that behaviour. Often, you know, dad has used violence against mum, child's seen that in early childhood, dad is out of the picture, and then once the child hits adolescence, he starts to essentially use what he's seen, tends to work and get results. But what we also have interrogated to less effect is the effects of trauma on kids' ability to regulate their own behaviour and emotions, the effects of trauma on the development of language, and therefore how strange it is that our system then expects them to be able to comply with instructions issued by the legal system when essentially their own development has been affected so deeply by their experiences. So I suppose I would throw to Brittany and Toby particularly to talk a little bit about what you see in terms of what kids have experienced once they get to your interaction, the point where you catch them. And even perhaps that we've had a question about the gender of respondents or kids using family violence, which the evidence again shows that it is gendered, but to a lesser extent than in adult populations. Brittany, did you want to go first?
You're on
Just
mute.
need to unmute.
I think the answer to that is that almost every young person that we see come through the system charged with this type of matter or responding to these types of restraint orders have some sort of trauma-based history, whether that's family violence or involvement with the child protection system in some other way in their formative years. I'm struggling to think of a case, for example, where that wasn't the situation. But also, the other really relevant factor is disability, and whether that's mental illness or whether that's intellectual disability or autism, that's another really strong factor.
Yeah, thanks, Brittany. And that's certainly something that's been asked about in the chat and is a strong theme and is affected by families' capacity to have that diagnosed, as we found in our research, as well as therefore the availability of services. And we know that the availability of services to support families with kids living with autism is particularly scarce. Toby, did you have a kind of comment on that?
Just quickly to reiterate what Brittany's saying there, I think it was 99% of the young people that came through Step Up had experienced some kind of trauma. And I just comment on the gender that we had about a 60-40% split, so 60% young men and 60% young females. And we tended to have more engagement from young women than young men, which again, I guess, is across the service sector. But yeah, I just reiterate what Brittany said there.
Another question or series of questions is focused around essentially the support that's available for adult victim survivors of adolescent use of family violence, and the fact that, and certainly this is the case in all the jurisdictions we looked at, our system is so geared very much to see people as either victims or perpetrators. It doesn't have a useful response when, say, a mum presents to a refuge with her kids who include an adolescent who might be using the violence that they've learnt or that is driven by their trauma. And our very sort of binary shaped system has no idea what to do with that. And one of the things that we've been trying to achieve with this project is to certainly help our system build in more nuance. So we're not seeing kids as perpetrators in this light, where they're children who are vulnerable by the nature of their being children, but often excessively vulnerable by virtue of the trauma they've experienced or the disability that they're living with. But did anybody have any, Helen, you might have a comment on that based on the conversations that you had during the course of the research. And you need to unmute.
Maybe not specifically on that, but I'm reminded about a particular conversation that we're talking about calling the police as a last resort, but the other avenue that families thought might be open was actually health services. So, you know, fronting up to emergency, and particularly the Royal Hobart Hospital, which has no dedicated mental health section for young children. And, you know, the parlour state of what's there for adults is another issue. But, yeah, I think, you know, there is... Ultimately, it all boils down to making the strong case that there is such a big need out there. And then the other big question, of course, is a question of resourcing. And we're talking about what could be done, but, you know, it's having the government will behind it to actually fund these sorts of initiatives and these programs.
Mm-hmm. And we have one last question. I'm conscious that we do need to end spot on 2, so I'll just kind of use this as a way of reflecting or wrapping it up. The question is, do we have a sense of where the children who come to the attention of authorities represent the true extent of adolescent family violence? And I would say absolutely not. And we know, obviously, that all forms of family violence are underreported, but there is particular stigma or, you know, anxiety associated with families reporting their own children. And so often families will desperately seek other forms of support until it's absolutely hit an absolute last resort, often for fear of their own safety or for the fear of their other children. But so what we know, and essentially what this project has been about, is getting a sense of how the system levers, whether that be legislative settings or other, dictate the visibility of an issue. Many families who are otherwise well-resourced will try and address the issue in-house with private counsellors and a whole range of things. So that nature of that issue won't be visible to us at all. But one of the things that is coming up is going to be very interesting to see how COVID will affect the visibility of the issue going forward, because we know anecdotally in Victoria, with our extended lockdown, rates of adolescent violence are going up, both in terms of the extremity of violence used by kids who are already doing so, and also the breadth of kids using violence who weren't using it before, and families, services that work with families, integrated family support and things like that, are reporting that to a significant extent. And the one final point I'll say, there is a question, a very, very important question. Did we get kids' points of views? No, we didn't in this research. We knew because it was a first step. So we've embarked on another project with Youth Law, the CLC working with kids in Victoria, who is running an early intervention program trying to get support to kids before they get to court. And as part of that, we're building in children's voices to the design and the ongoing reform of that project. Heather, that brings us to 2 o'clock.
All right, I think it's 1:59. So just I just want to take this opportunity to thank the panellists for the very interesting discussion this afternoon. Thank you, Elena, for the research that was produced that led to this, and thank the audience for tuning in this afternoon. And I wish you all a good afternoon.